welcome to Diversity Speaks, a webinar series that provides information on relevant and timely topics related to diversity, equity, and inclusion. For those of you who do not know me, my name is Raspreet Bhatia. I am the supervising attorney for the Financial Services Group out of our New York office, and I serve on Greenspoon Martyrs Diversity Council. This episode is the first in our Building Generational Wealth series. The intention of this series is to give everyone in the GM family access to the expertise that our attorneys have and to empower each of us to build generational wealth. More specifically, our hope is to serve those in our GM family who have been historically marginalized and are adversely affected by the generational wealth gap. Today, we will be speaking about estate planning with the co-chairs of the International Wealth and Asset Planning Group at Greenspoon Martyr, Carl Linder and Ed Brown. Ed Brown is a partner in our Denver office and has more than 25 years of experience in areas of comprehensive estate planning, asset protection, and taxation. He focuses his practice on trust designs that are customized to the client's goal of protection of assets for their family and having added flexibility in their comprehensive estate plans that allow maximizing options with regard to changing circumstances and evolving laws. Carl is a partner in our Miami office. Carl has advised individual family office and business clients regarding global and domestic estate and gift taxes, corporate taxes, international taxes, and state and local taxes. Carl also drafts wills, trust agreements, domestic and international asset protection trusts, life insurance trusts, revocable and irrevocable trusts, family limited partnerships and LLCs, and all other estate planning documents, including healthcare directives and durable powers of attorney. Both Carl and Ed are highly sought after to speak on their specialties, and we are very lucky to learn from them today. Before we begin, I would like to mention that at the end of the presentation, time permitting, we will have a Q&A. Please type any questions you may have in the Q&A section. With that said, I will turn it over now to Carl and Ed.
All right, thank you, Raspreet. I'll jump right in and kick this off in our short time we have together here. We want to cover, and Carl and I are splitting these up half and half, so I'll cover the first 5 gruesome estate planning mistakes that we see people making when they're trying to do their own estate planning without the involvement of an attorney. So we are going to hit the 10 greatest mistakes that we see most common. And this should give you guys a good overlay of sort of the things to think about with your own estate plan or other family members. So mistake number 1 that we run into is dying intestate. And this is Latin. This is the word. This doesn't mean, it's not interstate. This doesn't mean you died driving on the interstate. This means you died without a will, that you had no last will and testament drafted up during your lifetime. You're just depending on state law to decide who's going to get what upon your death. And the states do have very specific provisions as to where everything will go upon your death, all your cars, real estate, your cash, your brokerage accounts. It's all laid out under the statute, who's going to get what. But I don't think you're really going to like the plan that the state has provided for you. So you really want to have your own estate planning documentation set up so you can decide how things will be handled after your death and not let the state make those types of decisions. So we'll just jump right to mistake number 2. Next slide. You hear reference all the time for the people that say, well, I want to keep this simple. And we get that a lot from clients. They want this to be something quick, simple, and cheap. And so they want to do the I love you will. And that's just simply the expression to use to say, spouse number 1 says, when I die, everything goes to my spouse. And that's the end of the will. And the other spouse has the same thing. Well, when I die, everything goes to my spouse. Of course, then you got to address what happens if you're the second spouse to die. That doesn't quite work. But even if you're the right spouse who dies while you still have another spouse living, the I love you will is not something that we would suggest. I mean, for one, it simply hands the problems on to the surviving spouse. Now the surviving spouse has an estate to deal with. Now they got to come up with their own estate plan to decide where it goes from there. Also, there's no privacy involved. When you do a last will, naming spouse or whoever as the beneficiary, that's a public record. It can be, I guess, lodged with the court. Everybody can go online, see who's inheriting money from you. And that is something, again, that we'll talk about later on how you can avoid that lack of privacy. There's also a no protection in the sense that if you give everything to your spouse, and then let's say the spouse has a creditor problem later, maybe if it's a wife that survives, she is drinking too much at a cocktail party later on, runs a red light, hits the proverbial school bus with all these young kids, all of which would become, doctors and hedge fund managers and would have made a lot of money. And all of a sudden they're all damaged. And now there's a big lawsuit of, $8 to $10 million for all the loss of earning capacity that created through the car accident. So the fact that the spouse had inherited everything outright through an I love you will, all that can now go to the creditors and the plaintiffs in the lawsuit, and it's all gone. So jump to the next slide for mistake number 3. Some people talk about just giving everything outright to their kids or other heirs, nieces, nephews, whoever. Again, it's the same problems we talked about before. There's no privacy with a will, giving everything to the kids or heirs. There's no protection of those assets from their creditors. So you still got they're going to have to deal with probate when they die now because they've inherited everything outright. So again, this can all be avoided through, proper planning. Another thing too, with the lack of privacy is if the kids, for example, inherit everything, then all of the people that send you all those spam emails you get all the time, they look at the records of the probate courts and they see, oh, so-and-so has died and they've named Jim, John, and Sally as the beneficiaries. Let's start sending those people a lot of emails because now they got a bunch of extra money that they didn't have before. And we can start suggesting they buy a new car, brand new Cadillac, whatever. And all of a sudden they're going to get just hit by many, many solicitors trying to get them to spend their money. And it's interesting, if you weren't the one who earned the money, that spent all the blood, sweat, and tears to get that money earned in the first place, but you just inherited the money, it's a lot easier to not be as wise with that money. We see the people who have inherited money are more likely to squander it than people who earn the money. So let's give some examples in the next slide of what happens if you don't have an estate plan and you're just relying on the state law on who's going to get what. The state law very likely may say that everything, or at least a good portion of your estate without a will, is just going to go to your surviving spouse. Well, it's not unusual that the surviving spouse may get lonely sometime after the death of the first spouse, I don't know, a couple of weeks later, remarry. And all of a sudden there's a new spouse, potentially, a new spouse that's going to want to now have a different impression of where these assets should go ultimately. And as this example shows, if the husband is, well, as we say, Elaine, as we identify her as your husband's next wife in a husband-wife scenario here, the scenario is that Elaine comes over and starts doing the home-cooked meals, visits more and more often, starts not liking the decorating that was done by the prior spouse, and decides that, why let this money eventually go to the kids? We can spend it on more fun things while we're alive. So all of a sudden that inheritance can be dissipated and the children of the first spouse to die will never see a dime of it. So again, this can all be prevented with a properly structured estate plan, which we'll mention. So next slide. The state law without a will may also say that perhaps, and this isn't unusual, that maybe half the estate goes to the surviving spouse and the other half goes right to the children immediately. Doesn't wait until the surviving spouse has died. Again, that means that perhaps, let's say there's a daughter involved and she's married to Fred, who's your son-in-law. But Fred is not all that successful. As you can see here, he hasn't had a job since 1999, belongs to a cult, sells T-shirts at bands, and you suspect that he probably is fond of chemical substances. So again, you've maybe assets have now dropped into your daughter's lap, but now you're putting her in a position where she has to deal with the pressures of her spouse saying, hey, I've got better ideas for this money. Let's do this. I have a great new business venture. I think one of my best friends told me about. I think we should invest in there and make a bunch of money, you know. And all of a sudden it all gets lost in a terrible business deal. Again, the wiser parents that set up the will can make sure that this is not allowed, that kind of restricts what the daughter can do with the funds, instead of just having the daughter put all the money that she just inherited into a joint bank account with her husband, Fred. And another reason that that's a bad idea is if she does put it into a joint account with her husband, Fred, let's say Fred goes out and hits that school bus after drinking too much at a party. Now he has a huge creditor coming after him. Well, guess what? That joint account that has, you know, his wife's money in it, well, it's a joint account, so it's just as much his as hers. So that also could be taken by the creditor, and all of a sudden everything is gone. So next slide then. Here's the other possibility if you've just let the state decide who's going to get what. The state law might just say, well, everything you own gets split 50-50 between your two children, for example. So every piece of real estate you own, all of a sudden half that real estate's owned by your daughter, let's say, and half of your real estate is owned by your son. Well, let's say the daughter has some in-laws who are going to take advantage of this. They're going to start spending all the time they can over at this house that your daughter's inherited half of. I guess she has the right to live there too, because it's half hers. But now they're going to start moving in. They're going to want to have a nice in-law suite added on as a wing to the house. All of a sudden, she's going to be in a tough position, the daughter, to start saying no to her in-laws. And so if you do an estate plan, you can think all these things through. You can decide whether or not maybe you don't want the real estate to go to one particular child who has overbearing in-laws. You can be strategic and decide that there's a better way to have your assets allocated among your beneficiaries so that you avoid making these a problem for your children, as opposed to being, you know, a benefit to them financially. So let's jump on to the next slide. Oh yeah, there's always Marvin, the son. Again, he's a person that really tries really hard to make money, but again, 16 businesses he started, hasn't done well. Asked you to financially back all these. Needs to be bailed out. It's gone bankrupt twice already. Owes a bunch of legal fees and back taxes. Again, why have him receive assets outright through the state directed will, if you will, to who's going to inherit this money? All of a sudden he gets this money and he's got creditors in line saying, oh, this is great. You've inherited all this money. Now you can pay us. And by the time he's finished paying all those creditors, there's nothing left. So again, things could be set up in a way that Marvin can still benefit from these inherited assets without them being subject to these creditors coming in and grabbing them and taking them instead. So jump on next to our next slide. Mistake number 4 is you don't want to just have your attorney, if you're going to have attorney help you with your estate plan, just fill out forms. We've had this happen to us a number of times where the client thinks they're going to save some money, so they'll go download an estate plan, a last will, a revocable trust right on the internet, and they'll fill in it to the extent that they can, but then they have a few parts here and there they're just not real sure about, so that they'll then give it to the attorney and say, hey, can you just finish this up? Can you just look at page 2 and page 5 and just make sure that that reads right to you, and then give it back to me. And, you know, again, want this to be fast, cheap, and simple. So please don't spend more than a half an hour on this and get it back to me so I can get it signed and everything. So, you know, that's not what you pay the attorney for. I mean, it's just like paying your doctor. You're not paying your doctor to write out a prescription. It's all the consulting and making the right prognosis and diagnosis up front that you really are, you know, paying for. Same with the attorney. You want the attorney to design the estate plan and not just fill out a form and finish something up for you. And frankly, when we've been asked to look over a downloaded will or trust and just to make comments on it, it probably takes us as much time to scrutinize and critique that document as it would have been if we had just drafted from the start. And then you're not even done. Then you got to turn around and then implement all of the critiquing and suggestions that were made, which probably means you're going to end up having the attorney draft the will anyhow. So you probably just doubled your expenses as opposed to saved them. So I would definitely avoid that mistake. Mistake number 5. Not having a living trust. So this is what I was sort of indicating is the solution to a lot of these problems I've been talking about. If you only have a last will and testament that says things go to whoever, spouses, children, nephews, nieces, and you don't use a living trust, well, everything's got to go through probate. If you set up a living trust, and this is something you can do side by side with your last will and testament, you can have a living trust that your last will simply says, at my death, everything goes to my living trust. Document number 2, you keep them both together in your fireproof safe at home or your safe deposit box. And so that way, now you have the trust that's going to be the main document that's going to tell who gets what. And the reason that's a good idea is because things in a trust and who the beneficiaries are of the trust are, the beneficiaries named in the trust and how much they're each getting is not going to be public record. Your last will and testament is. So if your last will and testament says everything goes to my living trust, and that's what people can get a copy of going online to see who inherited the money, they're just going to see the name of a trust. So they're not going to know who to contact to start soliciting to try to sell them a new car. So you've got a nice privacy aspect by using that living trust. And the living trust can build in a lot of bells and whistles to make sure that the assets are protected, that avoids all the scenarios that I just talked about with the in-laws and the husband of your children or wife of your children, and the lack of the protection that just an outright distribution of the will going to those people would have otherwise caused. So I'm going to let Carl pick up from there on expanding on the living trust idea.
Next slide, please. So before I get into mistake number 6, I just want to address the whole point of estate planning, which is really to keep yourself organized in a methodology that makes your future administration post-death easy for your family. Now, we have over 100 people attending today, so thank you all. Attorneys are not great at doing their own planning. So every attorney should have a will and a living trust. Everyone that's listening, please write these 5 things down. Will, last will and testament, living trust, which is the same as a revocable trust, durable power of attorney, healthcare proxy, some people call it a healthcare surrogate, and a living will. Those are generally the 5 basic estate planning documents that you would want to have, as Ed alluded to, in your safety deposit box or in your safe at home. Those 5 documents is what we in the industry refer to as a basic estate plan. Now, today, individuals can die with $12,920,000 of assets each and not be subject to estate tax, which is slightly different topic than just having a basic estate plan. The vast majority of taxpayers in the United States never rise to the level necessary to actually do sophisticated estate planning for the tax piece. We have a lot of clients, Ed has a lot of clients that need that planning, and I'm sure several of you have clients that need that planning. And that's when you get a married couple that's getting in the $25+ million range. So all attorneys on the call, everybody who has a young family, if you're older, younger, you have earning potential, everybody needs to have a basic plan in place to remove the court and state law from the equation, which becomes important for people. So mistake number 6. Ed's last mistake was not having a living revocable trust. So mistake number 6 is not funding that trust. I don't know if you can see the word. It says not funding your assets into your trust. It's missing on the right side, but the Trust funding becomes a critical part of the plan. So what does that mean? You have to retitle all of your assets. So personally, I have my living revocable trust. I do my personal banking through that living revocable trust. I don't have a bank account in my personal name, because if I die, that account, however large it is, will go through the court system and probate. So to avoid the probate process, you want your assets funded into your revocable trust. And there are different types of assets. So there's simple personal bank accounts. You would retitle it to the name of your trust. There's stock portfolios, things of that nature. Those would be retitled to your revocable trust. There's interest in LLCs. There's interest in corporate entities. There's interest in limited partnerships. All of those entities require you to retitle them in the name of your trust. If you own an LLC today that owns a piece of property, maybe you have a rental property and you own it, you have to do a physical written assignment, assigning it to your trust, and have your trust accept that assignment. Again, assets that are titled to your trust will avoid the probate process and will be outside of the jurisdiction of the courts. It's also important because in the living trust, you appoint a successor trustee. Once I die, who's going to be the one that controls the trust assets? That individual has control over those assets as soon as they get a death certificate. Whereas if you don't have them in the trust and it goes through court, you got to get a personal representative appointed. That could take months. You have to then notice creditors. There's a whole process on how you get access to those assets, and you cannot distribute those assets without court approval generally. So mistake number 6, not funding your trust, critical to retitle assets. Next slide, please. Not having your documents updated and reviewed. It's critical to constantly review your documents. If it's every 3 years, 5 years, 7 years, whatever the number is, generally, if you have a life-changing event, you would want to update and review your documents. If you get married, if you have a child, if you move from one state to another, the laws vary state to state, you're going to want to update your documents. There's a case we have right now where a guy died, and in his will, he appointed assets to a former romance he had over 10 years ago. He never updated his documents. That lady just inherited a lot of money. He hasn't spoken to her in a decade. So you have to update your documents to make sure that, you know, your documents comport to what your desires and wishes are at the time. So updating becomes incredibly important. Also, fiduciaries. You know, there may be somebody that died that you named as your successor trustee or personal representative. You may not speak to that person anymore. So there's reasons to update documents, you know, various reasons. So you have to always keep up with that. Next slide, please. Relying on joint tenancy to avoid probate. Well, there is some value in having assets owned jointly. For example, in the state of Florida and 14 other states, we have tenancy by the entireties. Tenancy by the entireties is specific tenancy for marital units. And the reason it becomes important is for asset protection generally, because if both spouses own title together as a marital unit to an asset, one creditor cannot attack those marital assets if that creditor has a claim against one spouse. So tenancy by the entireties, we use it a lot in Florida, but for probate, it becomes difficult because the survivor now has to worry about getting that asset into their estate plan. And they may be elderly. They may be incapacitated at that time. So if you have a situation where there's a joint tenancy, again, we have tenancy by the entireties, we have tenants in common, which is basically a pro rata share by multiple owners. We have joint right of survivorship, which means the survivor inherits that asset. And if you do a joint right of survivorship, then all of those individuals need to participate in the future if you want to change something. So the tenant in common is different. Tenant in common is a 50-50. If there's two people, it's a 50-50 ownership. You can do what you want with your 50%. The other person can do what they want. But there are lots of issues that arise because you don't know what the future holds. And you want to have these assets in trust or in an entity, at least, that's owned by two trusts if you're a marital unit, so that you avoid these future problems in handling the joint tenancy. Also, just side note for asset protection, if you set up a tenancy other than a tenancy by entireties, that's special. But if you have a joint tenant with right of survivorship or a tenant in common, and none of those other owners paid for the asset, they just are on the titling, then the asset's going to be seen as your asset. And the protections that you might think you have may not exist. So it's important that you look at the joint tenancy titling, also keeping in mind that the second to die, as I mentioned already, or the survivor of the couple or the joint tenancy will have to do their planning at that time. And it's very difficult if you're not involved with them on a regular basis to assist them with that. And it's very possible that the survivor dies and that asset goes through probate. So obviously, it's very important to review those classifications. Mistake number 9, please. Thinking death documents are enough. Well, death documents, when we talk about that, we're talking about the last will, we're talking about the living revocable trust. For the most part, those documents do secure scenarios for the individual. But there are also other elements of people's lives that may not be included in there. So for example, one is life insurance planning. Life insurance is a key component to estate planning. And things to be aware of with life insurance, it's an interesting vehicle. The death benefit is never taxable on life insurance. So you can buy a ton of life insurance, leave it to beneficiaries. If they receive that death benefit, it's not taxable. But it is part of your taxable estate for estate tax if you own an insurance policy in your individual name and you die. So if you have $1 million policy, that $1 million policy, the death benefit would get added to your estate for the estate tax value. And depending on the size of your estate and depending on the exemption at the time, as I mentioned, right now it's $12,920,000 a person. Next year, it'll be close to 14 million. The year after, 2025, it'll go up to close to 15 million. And then it sunsets back to somewhere between 7 and 8 million a person in 2026. And the estate tax is something that is the constant football in the US Congress. You know, the Democrats and Republicans are constantly fighting about the exemption amount, about the estate tax in general. And there's a lot of uncertainty about what happens with the tax. So having a life insurance policy, like attorneys, you know, sometimes have large policies, especially if you're young. You can buy a term policy that's very inexpensive with a large death benefit, but potentially that death benefit could get pulled into your estate. And if it is, and you have a taxable estate, then it's possible that the death benefit in totality will not get to your beneficiaries because maybe some of that money will be needed to pay for estate tax. So there's also other areas that your death documents may not cover. For example, if you're a charitable person, you may need another type of structure. Or if you're looking to set up a foundation for charitable purposes, your death documents may not have a direct distribution to that foundation. So with charitable planning, you also need to look at documents, and they're various other things that arise in and outside of probate to be aware of, but that's for a different discussion. Mistake number 10. not understanding that the biggest enemy is not the IRS or the government. For the most part, as I mentioned, the IRS is concerned about taxable estates. In the United States, like 1% of estates are taxable. So it becomes really a non-issue for most decedents and their families related to the IRS or the government in that context. The other thing is that, you know, there are a lot of other issues with probate and estates, creditors. That might be one of your biggest problems and biggest enemies. Creditors have the right to claim assets in your estate. Creditors have the right to go after your revocable living trust for assets. So if you don't rise to the level of an IRS look, creditors is an issue. The other issue could be spouses, depending on, you know, how contentious a scenario is and depending on how documents were drafted. Siblings, litigation becomes big. I mean, we have some very large estates where litigation is prevalent. And it's generally some sibling suing another sibling that may be, you know, a personal representative or a successor trustee of their parents' estate. Maybe one sibling doesn't feel like they're getting enough. You might have lawsuits and you have time issues, which could be your biggest enemy. You could have cash flow issues, which could be your biggest enemy. If you have a taxable estate, the IRS gives you 9 months to pay the tax. If you don't have the cash flow to pay the tax, you have to liquidate assets. Sometimes you have to fire sale assets. If a client is heavy with real estate and doesn't have a lot of cash flow, but has a taxable estate, then you have to determine what assets are going to be sold rapidly. And some assets may not be eligible to be sold rapidly. So you have to deal with those issues. So it's not really the IRS that will apply to most people as the biggest enemy, although a lot of our clients are in that arena. Something I just want to talk about with estate planning quickly is that you may or may not know that there are potential discounts that can be had for an estate or a gift that's made when someone transfers a minority interest of a company or other asset. And it's very important that everybody talking about discounts with clients understand that there are some restrictions on that and case law on that has significantly changed the way those transfers are made. So if anyone's interested in learning more about discount transferring, Ed and I are happy to discuss the Powell cases and some of the other cases out there that you need to know about if you're talking about these issues. I do want to say that we're talking about diversity today. And so estate planning applies to everybody. Doesn't matter your color, creed, sexual preference, what state you live in, if you're married, not married, everybody needs a plan. And states that, for example, recognize marriages of the same sex, it's generally the same type of planning you would do for any couple in that context. And in states that don't recognize same-sex marriages, then you have to work within the state guidelines to make sure that you're drafting documents properly under that context. So this planning is for everybody. Next slide, there it is. Think about it. You need a plan today so that your later results are exactly how you desire them. Thank you.
Thank you very much for that. So at this point, I think it would be great if we can get into our Q&A. We did have some questions that we received previously before we started the presentation. So I'm going to go ahead and start off with the first question, and either one of you, please jump in and give us your wonderful answers, because we just got a lot of information. So we thank you, or I thank you for everything. Can you describe or explain how to maximize insurance as a method to create generational wealth?
Sure, I'll take that on. Yes, you can use what's called an irrevocable life insurance trust. And the way the trust works is it allows individual grantors to set it up for the benefit of their spouses or children or both. And as I said before, death benefits come in tax-free. The key to these trusts is every individual today has the ability to gift, and it's kind of a low number with families, but you can gift $17,000 per donee per annum. So there is some exemptions to that. For example, if a parent pays a university directly for tuition, that's not included in gifts. But for the most part, we leverage the gift to pay insurance premiums in life insurance trusts. And the way that works is that the parent or spouses would contribute the $17,000 if they can contribute the max amount. So if you have a married couple, it's $34,000, and you use that specific money to pay the premium. Now, there is some mechanisms of once you gift it, all of you from trust and estates and law school may remember a case called Crummy. So you have to issue a Crummy notice to the beneficiaries or to the guardian of the beneficiary if they're a minor that says Carl Linder made a gift of $17,000 to the trust. You have 30 days to pull the gift out. If you don't pull the gift out, the gift lapses and it becomes trust property. Generally, the gifts do not get pulled out, and then that trustee gets to use that trust property to pay premium. Those trusts can be dynastic to a certain extent. In the state of Florida, you can have an ILIT for 360 years. The rule against perpetuities, which everybody loves so much, is still active in some states. So you have to check the state law where you're setting up. But you can have these large death benefits come in tax-free. So as I mentioned before about if you own the policy and you die, it's in your taxable estate. If the trust owns the policy, it is not in your taxable estate. So talking about dynastic wealth, you can buy it in the trust, do not buy it in your name, and then transfer it to the trust because there's a 3-year look back on those transfers to pull it back into your estate for tax purposes. The other thing that's very common, at least for high net worth individuals, is premium finance life insurance, where the irrevocable life insurance trust goes out to a bank, takes a loan from a bank. Interest rates over the last 5 years were like below 2% on these structures. So it made a lot of sense because you're borrowing it too. And depending on the type of insurance policy, if it's an index policy, it was attached to the stock market and you're making 15-20% returns a year and having to pay interest at 2%, it made a lot of sense. Now interest rates are at 6, 7, 8% on these structures and the market's not been doing good. So index products may not be what you look at. And then there's whole life products, and that's a different model also. But in borrowing from the bank, you're able to keep your personal opportunity to grow your personal assets while financing the premiums for the life insurance. That financing is not considered a gift for tax purposes. So you can, as they say, OTP, you use other people's money to fund this structure with a very large death benefit. And when you die, the loan gets paid off from the death benefit. So you don't have to tap into your own money. The net proceeds then from the death benefit go into the trust for the benefit of your wife, kids, husband, whoever it is.
Got it. Thank you very much for that. I do have another question that was previously provided. I have a simple IRA from a long ago job. Can I move that into my 401k without tax consequences? And if not, what else can I do with it? Can I cash out without tax consequences? Is there not a lot of money? There's not a lot of money if it's less than 10K. So I guess the first question is, can they transfer it to a 401k without tax consequences?
Yeah, I'll start. Carl, you may have more experience with this than I do, but I as a general my general understanding is that you can roll over IRAs into a 401k. I think you have to look at, of course, the sponsor of the 401k plan to make sure that the plan accommodates that to occur. So I know that if you decide not to roll it over into a 401k, if that is possible under the employer's setup plan, you can draw the money out. But yes, that's going to be with taxation. That's going to be taxed as ordinary income. I know that some clients have looked into converting their IRAs into a Roth IRA, meaning that you still trigger a tax at the moment that you convert it over, but maybe you can do that at a time when maybe values are not so great with the market as we're talking about today. Maybe it is somewhat depressed. Maybe this is the time to trigger the tax. And then that way the future earnings in the Roth IRA at that point can continue to grow tax-free. And when you draw out those Roth IRA proceeds later, they're not taxed. I don't know if Carl, if you have more to add from your experience.
Yeah, the only comment I would make on that is we have rules on IRAs and 401ks related to age. So you're not eligible to pull out funds from those type of retirement plans without a penalty if you're below 59 and a half years of age. So there's a 10% penalty on the gross value at the time that you pull that out. If you cash out your IRA and you're 59 and a half or below, you will pay that 10% penalty as well. So it's generally not advisable to do that on a small, limited cash value retirement plan. Maybe it won't matter, but that's ultimately up to you to determine if you want to take that 10% hit on cashing out prior to the age requirement.
Okay, I hope that answers the questions. I'm now going to move to the Q&A. We have a few questions being put in here, and I'm going to read them off, so I apologize if I'm reading as I'm speaking. If there is, a mother has a special needs trust for a brother. More than 5 to 7 years ago, this was, hold on a second. Okay, there's a special needs trust that was created by a mother. That mother has since passed. The brother is living in an assisted living facility since the mother has passed. They are planning on using the personal monies and looking for Medicaid help to pay assisted living facility. They plan to use the funds in the special needs trust so that this brother can remain in a private room. The question is, if the brother passes, assuming there are still funds in the special needs trust, must those funds be used to reimburse Medicaid for all it paid the facility? Or can those funds be used to pay towards his or her will?
Well, I mean, generally speaking, the Medicaid will look for reimbursements from trusts that exist, special needs trusts or other. The language in the special needs trust also needs to be very detailed as far as restrictions are concerned on future payments. But generally, yes, they would look for reimbursement. There are cases where they don't look for reimbursement, but I've seen several where they have. So I would believe that you would be looking at a potential claim. There's always potential negotiation going back and forth related to that. But yes, you could be subject to a reimbursement claim.
Thank you. So our next question is there a particular age an individual should begin working on their estate planning?
Yeah,
Go ahead, Ed.
Yeah, I was going to say, no, there's no particular age. I think it's more your situation. I think as soon as you have any assets, you should start doing your estate plan, because if you have no assets, then I guess there's nothing to plan for. But if you have any assets, then assuming you're over the threshold, I think in Colorado, for example, if it's under whatever it is, $87,000 now, and there's no real estate, then you avoid a probate anyhow. So maybe you don't need a will in that situation, but you just never know. It's good to have one just in case you win the lottery 2 days before you bite the bullet. So it'd been nice to have that will in place. And also if you have minor children, so even if you have no assets, but you have minor children, which may be the reason you have no assets because they're expensive to have, but you would probably want to have a will to at least name the guardians of who's going to take care of these minor children after your death. So in that situation, I would say the sooner the better, regardless of your situation. Just get it set up and done now. You can always amend it as your situation changes in the future.
And I would make just a additional comment on that, which is some of the estate planning is for healthcare reasons. So it's not only about assets. I think the guardian appointment situation with minor children is critical, because if you don't name a guardian, you could have family members on both sides of the families fighting over who's going to get the child. And it's better that, you know, the couple determine who's going to get the child, and that if you are married, that your wills match up on that issue, you know, so that you say my brother, and your spouse says Carl's brother. And then after Carl's brother, you say who it's going to be together for the minor child. But the healthcare documents, the proxy, if you're hospitalized, you give power to somebody to make healthcare decisions for you. You have to name someone for HIPAA information, private information related to healthcare. And then the living will, which is, you know, for terminal conditions. You want to determine in advance, like, do you want certain medical procedures to be done to you if you're terminal, if you're in hospice, if you're, you know, do you want hydration? Do you want food? Do you want blood transfusions? Do you want surgeries? Do you want other types of technology? So there are reasons to have a plan other than assets, but the primary reason is assets.
Thank you. That was a great question, because I'm sure that answers something everyone's been thinking about. The next question is specifically for Carl. I know there was a lot that was discussed, but the question's asking you if the trust you were speaking about was an irrevocable trust.
Well, there's a difference between revocable and irrevocable. When I said insurance, I was talking about irrevocable. When you have an irrevocable trust, generally the assets are protected and the beneficiary's internal are protected, and the trustee has discretion on how they distribute money to or on behalf of those beneficiaries. Could pay rent directly, car payments, credit cards directly. So irrevocable is where, you know, they don't control anything. Generally speaking, irrevocable strips control, and irrevocable is not included in your estate. Revocable is where you serve as your own trustee for the most part. You control it on a day-to-day basis. You make all the decisions. You sign on the bank accounts, and that's not asset protected. So there's reasons to use these trusts with large gifting clients that have the assets above the exemption, 25 million or above, or if you're single and you have 13 million and above, then you might use an irrevocable gift trust, because you want to be able to move it into a structure that keeps it protected for your family and doesn't allow creditors to attach on it. So irrevocable, generally, I would say, is more asset protection and dynasty based, and revocable has no asset protection, but you maintain all the control. And there are a lot of different types of trusts out there. The most basic is revocable, but there's several types of irrevocable trusts as well for planning.
Thank you. Next we have, is paying a child's student loans the same as paying a university, or is that part of the gift amount?
I would say that's part of the gift amount, because the statute says that it's not treated as a gift if you pay the money directly to the educational institution. So I don't think a loan would cut it.
You would be limited to the 34,000 per year. Now, keep this in mind. Everybody gets the 12,920,000, but they get 34,000 exclusion where you don't have to do anything. You can give that money. No one will question it. You'll probably get no questions about it ever. But if you go above the 34,000 as a married couple, you simply file a gift tax return, eating up some of your additional credit till you hit that number of 12,920,000. So if your child has loans of 150,000, Well, you could do it 5 years, 34, 34, 34, and pay it off over 5 years. Or you could give the full 150 minus the 34, you would file a gift tax return of 116,000, eating up that amount of the 12,920,000. So you can do it, you just eat into your credit. Well, if you're paying off student loans, depends what your net worth is to whether or not that's going to make a difference later on your estate tax. But generally, it's a non-issue, and you just file your gift tax return showing that you made that payment non-taxable.
Thank you. So for our final question, it's more of a example scenario. A Florida resident husband is a beneficiary of a trust account set up by his father. This income has been household income for over 12 years, the number of years married. Wife is not named as a beneficiary because the husband was single at the time of the father's death. Can the wife have any claim to this trust?
The wife of the son?
The wife of the husband. The husband's father is the one who passed. He's the one who had the trust account. They were not married at the time of the father's death. But the income has been household income for over the last 11 years, and that's the time they both been married.
So the father was not married to the mother.
The father passed away.
Okay.
His son, is my understanding, is the one who's getting the income. And the son's wife, the question is that wife going to have a claim to the trust?
Generally, no. We have a case in Florida that is a trust case. It was an irrevocable trust case where the couple was funded exclusively by the husband's family. And I mean, in this case, it was the wife's family. And so if there's a structure of where like gifting was occurring, gifting was supporting the couple from a trust that was a family trust, and the spouse dies and or they get divorced potentially, the case is it's called Berline, then they allowed that spouse to sue the trust in divorce, and that spouse collected on assets as if they were marital assets. So I'm not convinced that a spouse wouldn't collect. I mean, you can make it very hard in the drafting of trust documents and the use of entities and control features and other things, but that case is out there. So if there is a potential claim, depending on the facts. Now, if there was, because you said that the son was getting all the income from the trust, so that could potentially trigger that interest. The way they treat it is they treat it as marital property. So I believe there could be a claim, yes.
I wanted to give you both a huge thank you for all of the knowledge that you've provided. For anyone who is joining and you have any questions, please feel free to send any of the questions back so there could be further clarification given. Thanks to everyone who was able to join us today. And we hope that we can see you on the next episode that we are going to be hosting. Thank you, everyone. Have a wonderful day.
Thank you.
Thanks.